Human rights in Israel refers to the human rights record of Israel as evaluated by intergovernmental organizations. Non-governmental organizations and human rights activists are often in the context of the Israeli-Palestinian conflict, the wider Arab-Israeli conflict, and Israel's internal politics. Israel is a multi-party parliamentary democracy. It was described in its Declaration of Independence as a Jewish state. The definition Jewish and democratic state was adopted in 1985. In addition to its Jewish majority, Israel is home to religious and ethnic minorities, some of whom report discrimination in the Palestinian territories. Successive Israeli governments have been subject to international criticism from other countries as well as international human rights groups. One of the basic laws of Israel, intended to form the basis of a future constitution, basic law, human dignity and liberty, is a major tool for safeguarding human rights and civil liberties in the State of Israel. History. The Council of the League of Nations adopted a resolution on the 4th of September 1931 regarding the general conditions required before the Mandate regime could be brought to an end. The new government was to provide an oral or written declaration acknowledging acceptance of an obligation to constitutionally guarantee the equal rights of ethnic and religious minorities. That resolution followed a long-standing precedent of international law in cases where the great powers had assisted in the restoration of sovereignty over a territory. The UN resolution on the future government of Palestine contained both a plan of partition and a minority protection plan. It placed minority, women's, and religious rights under the protection of the United Nations and the International Court of Justice. The plan provided specific guarantees of fundamental human rights. The new states were to supply a declaration, which according to precedent was tantamount to a treaty. The resolution stated that the stipulations contained in the declarations are recognized as fundamental laws of state, and no law, regulation or official action shall conflict or interfere with these stipulations, nor shall any law, regulation or official action prevail over them. The resolution also required that the constitution of each state embody the rights contained in the declaration. During the hearings on Israel's application for membership in the United Nations, Abba Eban said that the rights stipulated in UN Resolution 181 had been constitutionally embodied as the fundamental law of the State of Israel as required by the resolution. The instruments that he cited during the hearings were the Declaration of the Establishment of the State of Israel, and various cables and letters of confirmation addressed to the Secretary-General. Eban's explanations and Israel's undertakings were noted in the text of General Assembly Resolution 273, admission of Israel to membership in the United Nations. The 11th of May 1949, the Declaration of the Establishment of the State of Israel proclaimed on the 14th of May 1948 that the right of the Jewish people to national rebirth in its own country, was recognized in the Balfour Declaration of 2 November 1917, and reaffirmed in the mandate of the League of Nations, which, in particular, gave international sanction to the historic connection between the Jewish people and Eretz Israel and to the right of the Jewish people to rebuild its national home. It also declared that the state will be opened for Jewish immigration and for the ingathering of the exiles. It will foster the development of the country for the benefit of all its inhabitants. It will be based on freedom, justice and peace as envisaged by the prophets of Israel. It will ensure complete equality of social and political rights to all its inhabitants, irrespective of religion, race or sex. It will guarantee freedom of religion, conscience, language, education and culture. It will safeguard the holy places of all religions, and it will be faithful to the principles of the Charter of the United Nations. Some British academics argue that Israel has not fulfilled its obligation to constitutionally protect minority rights. In 1950, Israel was admitted to the United Nations in accordance with General Assembly Resolution 273 of the 11th of May 1949. The Israeli Supreme Court has ruled that the Declaration of Independence is not a constitution and cannot be used to invalidate laws and regulations that contradict it. Israeli Basic Law, Human Dignity and Liberty, states that fundamental human rights in Israel shall be upheld in the spirit of the principles set forth in the Declaration, but it specifically exempted legislation that was already in force. Israeli legal scholars say that the wording of the law was adopted to avoid the difficulty of giving priority to equality, which was not expressly entrenched. The result is that the principle of equality can be reversed by ordinary legislation, and furthermore will not override statutory or judge-made laws. The United Nations and its subsidiary organs say that Israel has a binding legal obligation that flows from Resolution 181 and that the United Nations has a permanent responsibility in the matter.